Hi class, welcome to Legal Aspects in Hospitality and Tourism. And for this lesson, we will tackle the Philippine Constitutions and the selected provisions that we can apply in hospitality and tourism. Okay, so before we go on, let's define first what is the Constitution. Constitution is defined as the original and fundamental principles of law by which a system of government is created and according to which a country is governed. From the past lessons, napag-usapan natin na ang konstitusyon ay ang saligang batas at ito ang highest law of the land na kung saan at ang ibang mga batas ay dapat sumunod dito. The fundamental law of the land to which all other laws must conform. It is a written instrument by which the fundamental powers of the government are established, limited, and defined, and by which those powers are distributed among several departments for their safe and useful exercise for the benefits of the body politic. So kung titignan nyo ang Philippine Constitution natin, yung first page na makikita natin doon is yung preamble. And most of the professors, teachers, pinapamemorize nila yung preamble ng Philippine Constitution. So here is the preamble of the 1987 Constitution. We, the sovereign Filipino people, imploring the aid of Almighty God, in order to build a just and humane society and establish a government that shall embody our ideals and aspirations, promote the common good, conserve and develop our patrimony, and secure to ourselves and our posterity the blessings of independence and democracy under the rule of law and a regime of truth, justice, freedom, love, equality, and peace to ordain and promulgate this Constitution. But actually, class, what is the function of the preamble in the Constitution? The preamble is not a source of right or obligation. Hindi pa siya batas, okay? But it's just an introductory part of the said book. However, it sets down the origin, scope, and purpose of the Constitution. It is useful as an aiding ascertaining the meaning of ambiguous provisions in the body of constitutions. Okay, now let's move on to Article 3. So ito yung marami tayong makuha provisions na applicable sa legal aspects in tourism and hospitality. So Article 3, Bill of Rights, and the Article 12, National Economy and Patrimony, are some of the Constitution provisions related to tourism which may be given preferential attention. Now let's move on first to the Article 3 of this Constitution, which is the Bill of Rights. So by the way, what is Bill of Rights? Bill of Rights are the set of prescriptions setting forth the fundamental civil and political rights of the individual and imposing limitations on the powers of government as a means of securing the enjoyment of those rights. So what is the significance of Bill of Rights? The Bill of Rights is a guarantee that there are certain areas of a person's life, liberty, and property which governmental power may not touch. So pakatandaan natin na ang bawat departamento sa ating gobyerno may kanya-kanyang kapangyarihan. At minsan, kung nasobran sa kapangyarihan ito, maaari nilang maabuso. At ang Bill of Rights naman ay siyang susuporta at papangalagaan ang karapatan ng mga tao. So Bill of Rights, Article 3, Section 1, no person shall be deprived of life, liberty, or property without the due process of law, nor shall any person be denied the equal protection of the laws. Under the Constitution, the term life, of which a person may not be deprived without due process, means more than animal existence. According to Justice Malcolm, liberty means that measure of freedom which may be enjoyed in a civilized community consistently with the peaceful enjoyment of life, freedom in others. Okay, so the definition of property is defined as anything which is or may be the object of appropriation, while the definition of equal protection of the laws means persons similarly situated should be similarly treated. There should be no favoritism, pantay-pantay ang pamumuhay ng bawat tao. And the term due process of law is a law which hears before it condemns, which proceeds upon inquiry and renders judgment after trial. And now let's jump to section 3 of the said article. The privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purposes in any proceeding. So ano nga bang ibig sabihin ng section na ito? Meron tayong privacy of communication. Halimbawa, ang hawak yung cellphone ngayon, meron kayong karapatan na wag itong ipakita sa iba dahil may nilalaman itong mga messages. So for example is the Republic Act number 4200, otherwise known as the Anti-Wiretapping Law, provides penalties for specific violations of the privacy of communication. Pero merong exemptions sa rule na ito. Pwedeng kunin ang communication as long as under these certain crimes. Any evidence obtained in violation of the above shall be considered fruit from the poisonous tree. Kung gagamitin naman ito as an evidence, hindi pa rin tatanggapin ng korte dahil ito ay magiging fruit from the poisonous tree. Okay, Section 4, no law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble the petition, the government for redress of grievances. So, anong ibig sabihin nito? Before we go on, let's define first what is the definition of those speech, expression, and press na sinasabi. So, speech, expression, and press include every form of expression, whether oral, written tape, or disc recorded. It is also included movies as well as what is referred to as symbolic speech. So, meron din dito yung wala kang sinasabing salita, pero nakasuot ka naman ng isang bandana, and as a symbol of protest, merong expression na pinapahayag doon. Okay, so wala daw batas na dapat ipatupad na kung saan magbabawal sa freedom of speech, expression, and press. Section 5 of the said article, no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof, the free exercise and enjoyment of religious profession and worship, without discrimination or preference, shall forever be allowed. No religious test shall be required for the exercise of civil or political right. So we have two principles parts of this section 5. They are first, the non-establishment clause. It prohibits the establishment of any religion. So, hindi pwede ng isang kumpanya pinagtatrabuhan nyo o kahit yung bansa natin na mag-install sa atin na dapat ganito ang religion natin. And the other one is the free exercise clause na kung saan sinasabi naman dito, it guarantees us to the free exercise of religion. So yung isa naman, yung kung isa kanina, nagbabawal siya na magbigay ng religion sa isang individual, ito naman hindi rin pwede na pagbawalan ka na mag-exercise ng religion mo as long as yung religion mo hindi naman nakaka-harm ng ibang individuals or ibang citizen. Okay, Section 6. The liberty of abode and of changing the same within the limits prescribed by law shall not be impaired except upon lawful order of the court, neither shall the right to travel be impaired except in the interest of national security, public safety, or public health as may be provided by law. So ano nga bang ibig sabihin ng section ito? The liberty guaranteed by this provision includes, first, freedom to choose and change one place of abode. Pwede kang lumipat. Okay? Second, freedom to travel both within the country and outside. May kalayaan kang mag-travel at kahit sa labas pa ng bansa. Though, this section is not absolute since makikita natin na meron itong exemptions na kung saan pwede, maaari ang gobyernong pagbawalan ka na mag-travel or lumipat kung involved dito yung public safety or public health. So yun nandun sa batas na binasa natin kanina. Now let's move on to Section 8, the right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law shall not be abridged. So ano ibig sabihin nito? We have the right to form associations and shall not be impaired without due process of law. It is therefore an aspect of the general right of liberty. More specifically, it is an aspect of freedom of contract and is so far as associations may have for their object the advancement of beliefs and ideas. Freedom of association is an aspect of freedom of expression and of belief. So may karapatan tayong sumali sa organisasyon as long as yung organization na yan ay hindi kumakalaban sa mga batas. Okay, Section 9, Article 3 pa rin tayo, Bill of Rights. Private property shall not be taken for public use without just compensation. So, ano nga bang ibig sabihin nito? Wala daw dapat property na kukunin na hindi ka nagbibigyan ng compensation. Okay? So, actually, this power of the government is called the power of eminent domain. It is the ultimate right of sovereign power to appropriate not only the public but also the private property of all citizens within the territorial sovereignty to public purposes. So, yung government daw, meron daw kapangyarihan na kunin ang mga property as long as yung pagkakuha ng property gagamitin ito sa public use. Okay. So, what are the elements of the exercise of the power of eminent domain? First, there is taking of private property. Merong kinukuha ang private property. And second, the taking must be for public use. Kinuha ito dahil gagamitin for public use. And third, there must be just compensation. Yung may-ari ng private property dapat bibigyan ng just compensation. Now, let's move on to the Article 12 of the 1987 Constitution, the national economy and patrimony. Section 10, the Congress shall, upon recommendation of the Economic and Planning Agency, when the national interest dictates, reserve to citizens of the Philippines or to corporations or associations at least 60% of whose capital is owned by such citizens, or such higher percentage as Congress may prescribe certain areas of investments. In the grant of rights, privileges, and concessions covering national economy and patrimony, the state shall give preference to qualified Filipinos. The state shall regulate and exercise authority over foreign investments within its national jurisdiction and in accordance with its national goals and priorities. So what was the provisions all about? It allows the nationalization of certain businesses covering national economy and patrimony has not been considered a new doctrine. Okay, in the case of Ichong versus Hernandez, so makita natin sa case na ito, Philippinization of business may be done without violating the Equal Protection Clause. Okay, the patrimony of the nation that should be conserved and developed refers not only to our rich natural resources but also to the cultural heritage of our race. Pinapangalagaan din natin hindi lang ang kalikasan, kundi yung mga lugar na sumasalamin sa kultura ng mga Pilipino. In its plain and ordinary meaning, the term patrimony pertains to heritage. When the Constitution speaks of national patrimony, it refers not only to the natural resources of the Philippines but also to the cultural heritage of the Filipinos. Ito naman, yung term na qualified Filipinos na nabanggit sa Section 10 ng National Economy and Patrimony simply means that preference shall be given to those citizens who can make a viable contribution to the common good because the credible competence and efficiency. So dapat ang nagmamayari mga napag-usapan natin kanina are para lang sa mga qualified Filipinos. In the granting of economic rights, privileges, and concessions, when a choice has to be made between a qualified foreigner and a qualified Filipino, mas pipiliin natin si qualified Filipino. Okay, another case. During a bid for the purchase of the majority shares in Manila Hotel, a Malaysian corporation was the highest bidder. So merong gustong bumili ng Manila Hotel at ang highest bidder daw that time ay ang Malaysian corporation. Pero alam niyo ba na napunta ito sa Filipino corporation kahit mas mura ang pagbili nila? Here's the legal opinion. Article 12, Section 10 of the 1987 Constitution explicitly states that the granting of privileges involving national patrimony shall give preference to qualified Filipinos. Yan ang binabanggit ko kanina. As held in the case of Manila Prince Hotel versus Government Service Insurance System, GR number 122156, February 3, 1997. So here's the ruling of the court. The Manila Hotel has become a landmark, a living testimonial of Philippine heritage. While it was restrictively an American hotel when it first opened in 1912, it immediately evolved to be truly Filipino, formerly a concourse for the elite. It has since then become the venue of various significant events which have shaped Philippine history. So marami ang naganap sa Manila Hotel na part na ng Philippine history. It was called the Cultural Center of the 1930s. It was the site of the festivities during the inauguration of the Philippine Commonwealth, dubbed as the National Guest House of the Philippine government. It plays host to dignitaries and official visitors who are accorded the traditional Philippine hospitality. The history of the hotel has been chronicled in the book The Manila Hotel, the heart and memory of a city during World War II. The hotel was converted by the Japanese military administration into military headquarters. When the American forces returned to recapture Manila, the hotel was selected by the Japanese together with Intramuros as the two places for their final stand. So ang ibig sabihin lang nito, ang Manila Hotel ay part na ng Philippine history. Kaya narapat lang ang magmay-ari ng Manila Hotel ay Filipino Corporation and not by any foreign corporation. Now let's move to Section 11 of National Economy and Patrimony. No franchise, certificate, or any other form of authorization for the operation of public utility shall be granted except to citizens of the Philippines, or to corporations or associations organized under the laws of the Philippines, or at least 60% of whose capital is owned by such citizens. Nor shall such franchise, certificate, or authorization be exclusive in character or for a longer period than 50 years. Neither shall any such franchise or right be granted except under the condition that it shall be subject to amendment, alteration, or repeal by the Congress when the common good so requires. The state shall encourage equity participation in public utilities by the general public. The participation of foreign investors in the governing body of any public utility enterprise shall be limited to their proportionate share in its capital, and all the executive and managing officers of such corporation or association must be citizens of the Philippines. So ano nga bang sinasabi ng section na ito? The first sentence provide that public utility franchise will be granted only to citizens of the Philippines or to the corporations at least 60% of the capital of which is owned by citizens. Kung magkakaroon daw tayo ng foreign investors at magkakaroon ng business sa Pilipinas, dapat ang 60% ng corporation na ito ay nanggagaling sa Pilipinos, pagmamayari ng Filipino, at ang 40% naman ay para sa mga foreigner. And the second sentence allows the legislature to impair the obligation of franchises when the common good so requires. The last sentence authorizes the participation of foreign investors to participate as board of directors of these public utility enterprises, but shall be limited to their proportionate share in the capital as mandated in the first sentence. However, the executive and managing officers of such public utility enterprise must be citizens of the Philippines. Okay, the term public utility is defined under Commonwealth Act number 146 section 13, though nabago na ang definition ng public utility since ang pagkakaroon natin ng foreign direct investment noong 1991 ay binago ni President Rodrigo Roa Duterte nitong 2022 lang. Ang ibig sabihin nun, may panibago tayong provisions na binago ang definition ng public utility at ang epekto nito ay ang pagbibigay ng 100% ownership sa mga foreigner sa mga piling business. Take note, hindi lahat ng business, kundi piling business, pwede na silang pumasok sa Pilipinas, mag-invest at mag-work sa business. So ito yung sinasabi kong batas under the administration of President Rodrigo Roa Duterte, the Republic Act 11647, signed on March 2, 2022, seeks to ease foreign equity restrictions in certain sectors. A copy of a new law was released by Malacanang. So merong binigay na copy ang Executive Department na kung saan pwede daw, may mga piling businesses na pwede mag-invest ang mga foreigners ng 100%. Foreigners engaged in export enterprises can now secure 100% ownership in areas outside the foreign investment negative list under the new law. So meron akong bibigay na video presentation regarding sa bagong batas na ito. Section 14, still under the National Economy and Patrimony, Article 12 of the 1987 Constitution, the sustained development of a reservoir of national talents consisting of Filipino scientists, entrepreneurs, professionals, managers, high-level technical manpower, and skilled workers and craftsmen in all fields shall be promoted by the state. The state shall encourage, appropriate technology, and regulate its transfer for the national benefit. The practice of all professions in the Philippines shall be limited to Filipino citizens save in cases prescribed by law. So anong ibig sabihin ng provision na ito? It mandates that the practice of a profession is reserved exclusively to citizens of the Philippines. Sa madaling salita, ang batas ito nagpoprotekta sa mga Filipino citizens na professionals. Halimbawa na lang ang mga doktor at mga abogado, sila ang may karapatang mag-practice sa bansa natin. And that's it. Thank you.